I know that I say this occasionally and it never works out, but here I go again. I think this is going to be a pretty short lecture because, and this is something I mentioned last time, there just isn't that much going on in these cases and these doctrines. They're not very well thought out. They're not very formalized. They're not very reasoned, which makes them interesting in the sense that the justices who are writing these not very formal, not very worked out theories that are totally fact-dependent and rely on this balancing of interests are the very same justices who in every other context says we must have formal rules, we must not have balancing tests, we must not worry about facts of the case. So there's that, if you like. There's a certain inconsistency, and if you take a satisfaction in pointing out the inconsistency of justices whom you don't like, and who among us can honestly say we don't do that? Okay, that was it. Among those of us who are legal geeks, who among us can say we do not do that? How's that? Normal people, I realize that's not what people do. But, so I mean, I guess aside from that bit of failed snark, nothing is more embarrassing than failed snark. I guess what's interesting is how different this sounds than all the other areas we've looked at over the course of the semester, at least since the 30s. Right, so we've all been about formal tests and specific rules, and yes, sir.
Are you recording?
I am recording.
Oh, okay. I didn't hear you say I'm recording.
Thank you.
I didn't want you to have to start.
No, I appreciate that. And the people at home would have missed that moment. Would have been a shame. All right, let's just dig in. Graham versus Connor is one that we mentioned last time. In the notes last time, or the notes for last time, I had a line that says this is a qualified immunity case. That's not actually right. It's with the qualified immunity materials, but it actually establishes a kind of predecessor point. Partly the one I already told you about last time, the specificity idea. If there's a specific constitutional provision, like an amendment, that covers a rights claim, the courts will look at that rather than a broader substantive due process kind of theory, and we mentioned that last time. Here it is again. So this is a case in 1989, and as always, I'm struck by that this is not 1949 or 29, we were still working this out in 1989. About how do we evaluate claims that the police have used excessive force? Just in the broadest possible terms. What constitutional amendment applies here? That sort of thing. The case had to do with it. I mean, as always, the facts are kind of gruesome and appalling. The case was a diabetic, involved a diabetic who was having an insulin crash. I don't know if any of you know people who are diabetics or have been around them, but if someone who's diabetic has an insulin crash, they often they sound crazy. They lose their balance, they have trouble speaking articulately, they lose a certain degree of self-control. So this guy was sort of staggering around. His friend told the cops he's diabetic. He needs some sugar, but they ignored him. They beat him up pretty thoroughly. He had a broken foot, a cut wrist, a bruised forehead, an injured shoulder, and persistent ringing in his ears, having his head slammed on the hood of the car. The cop relied on common sense. Just like last time, one of the cops said, I've seen a lot of people with sugar diabetes that never acted like this. Ain't nothing wrong with this MF, but drunk, lock the SB up. All right. Now, two things about this are interesting. Oh, see, interesting is just the wrong word. This is a Terry stop. This isn't an arrest. Right, remember, and you're going to be amazed, I think, today how much work Terry does. As a principle. So remember, the Terry principle says, police officers see someone with respect to whom he or she has a reasonable suspicion that they might be involved in illegal activity. And last time, we got kind of the strong version of that, which said, if it's ambiguous, the policeman may err on the side of being suspicious. And get a Terry stop, a inquiry and a pat-down search. Now last time, looking at Rochin and looking at the other cases, I don't know if you noticed this, but there was a huge tension between saying, on the one hand, if a policeman wants to ask you questions, remember Illinois versus Wardlow, the guy who ran. The guy who ran. One of the things we heard in that case was, if a policeman wants to ask you questions, you are free not to answer, and you are free to go about your business. But Terry says the police officer is free to stop you, ask you questions, and search you. Those point in opposite directions. And the distinction is supposed to be that there's a reasonable suspicion, but as we saw last time, the barrier for the threshold for reasonable suspicion is pretty low. looks nervous, is located in a high crime neighborhood, runs when 14 police cars come streaming up to the block. I'd be much more concerned about someone who wasn't nervous when 14 police cars come streaming up to the block. That's a cold-blooded person right there. All right. So this case is a guy who, as I say, I mean, obviously he was not doing anything criminal. He was not stoned. He was not drunk. He was diabetic. There was a guy saying to the police, hey, he's diabetic. And as I mentioned, he got beat up very thoroughly. These are pretty severe injuries. But it was a Terry stop. It wasn't even an arrest. The police had no right to take him into custody. According to what we saw in the last lecture, he had every right to go on about his business or to refuse to answer questions. So the whole idea that a Terry stop may be accompanied by violence and that it may escalate, right? If you resist the pat down, then there's a level of violence they can use to force you. If you resist that, there's the next level of violence, right? It always is an escalating cycle of reaction to resistance, which makes it very hard to understand in Wardlaw what they meant when they said you have the right not to answer questions and go on about your business as long as you don't look nervous or run. Anyway, the point of this case is simple. You could make an argument that beating somebody up for no good reason, as it turns out, based solely on the fact that you thought they were acting strange, and with no more authority than an authority to do a casual Terry stop, violates our notions of due process, fundamental canons of decency of English-speaking people, all that stuff. You can make it a substantive due process argument, but we're not going to do that. And at this time, there had been a couple, one in particular, earlier cases in which that had been done. So this is a new rule. One of which is mentioned, I'll get to it. Right, so we're not going to do that. Where a specific, same thing I said last time, where a specific amendment applies, we'll apply it. Fourth Amendment applies here. This is a Terry stop. It's a Fourth Amendment stop. Unlike Rochin, where the focus was what took place inside the police station, which is beyond the Fourth Amendment. All good? I'm just trying to make sure that today we don't lose sight of last time because it builds. Second, that's right, now we're going to a little more elaborate version of the principle. Second, given that I just said, or the court just said, we're going to look to the specific amendment to determine the right at issue and its standard. The consequence is that in different situations there will be different standards because there are different rules for how to interpret different amendments. As we've said many times, 1983, that's 42 U.S.C. 1983, is not itself a source of substantive rights. It merely provides a method for vindicating federal rights elsewhere conferred. So if you're looking at an excessive force claim under 1983, quote, analysis begins by identifying the specific constitutional right. And the word specific should set off a bell in your head because we've seen repeatedly how important that becomes. Allegedly infringed by the challenged application of force. In most instances, that would be either the Fourth or the Eighth Amendment. And they set the example of Tennessee versus Garner. Now, we didn't read Tennessee versus Garner. I don't want to talk about it much, but I want to mention it because, as I said, cases in this area are always very fact-specific. The facts are often kind of gruesome or upsetting, if you let it upset you. And regardless of what period we're talking about, whether it's the Warren Court or the Rehnquist Court or the Vinson Court, the courts are they're extremely deferential to the police, let's put it that way. So Tennessee versus Garner involved an unarmed man running away from a policeman, and the policeman shot him in the back and killed him. That was held not to be misconduct because the policeman had reason to believe that if this guy got away, he might commit acts of violence in the future. I just thought that was worth mentioning as we go by. All right, so we've said you have to figure out which is the amendment, and you have to choose a particular amendment, and this is another example of a rule of specificity. By the way, that's my phrase. I've been hammering the word specificity. That's just the word I've been using to describe what we're talking about. It does show up in a couple of cases, but when you leave here, if you say, oh, it's a rule of specificity, people will look at you oddly. But you can certainly say it is the principle that rights must be defined with specificity, as in Glucksberg, and everybody will know what you're talking about. So because the Fourth Amendment provides an explicit textual source of constitutional protection, that amendment, not the more generalized notion of substantive due process, must be the guide. Okay, so how do we do that? Well, we have to ask about reasonableness. Determining whether the force used to effect a particular seizure is reasonable, pause. Where does reasonableness come from here? Well, the word unreasonable in the Fourth Amendment. Now, once you've chosen an amendment, that involves, now we know what our key terms are, our key concepts, where, from what other kinds of contexts we're going to borrow ideas and tests, and where we are not. Since we're not doing substantive due process, we're not going to talk about Palco, we're not going to talk about Glucksberg. Since we are doing Fourth Amendment, we're going to look to other Fourth Amendment discussions of terms like the word reasonable. Always watch the vocabulary. Determining whether the force used to effect a particular seizure is reasonable under the Fourth Amendment requires a careful balancing of the nature and quality of the intrusion on the individual's Fourth Amendment interests against the countervailing governmental interests at stake. Two things about this. This is not the first time we've heard this liberty interest or balancing of interests talk, so that you have the government's interest and the individual's interest. You might pause and ask yourself if that's the best way to talk about things that we usually call constitutional rights. That is, the strong rights tradition, which emerges most clearly after World War II, holds that rights are something more than merely interests, which is why we justify, sort of analytically, how we justify saying once government action reaches the point of infringing on rights, we jack up the tiers of scrutiny. The government needs a compelling interest, or at least an important interest, or something. In this context, I purchased a cup of coffee and I've lost it. That's kind of extraordinary. I thought it was this, but this is empty. Somewhere there's a very nice cup of coffee. Wow. All right. More unintentional humor, I hope. Don't forget to tip your server. Okay. Right. So here it's a bare balancing of interests. There's the state's interest in preventing crime and the individual interest in having their Fourth Amendment rights protected. Our Fourth Amendment jurisprudence has long recognized, right, because we're in the Fourth Amendment, we'll draw on the line of Fourth Amendment cases, not the whole universe of constitutional law. The right to make an arrest or investigatory stop necessarily carries with the right to use some degree of physical coercion or threat to effect it. See Terry versus Ohio. So in a Terry stop, again, that's where there's no probable cause, there's no necessary evidence you've committed a crime at all, there's a reasonable suspicion. And remember, the original case of Terry was two guys looking at a store window and walking away and coming back. And the cop said, maybe they're casing the joint. And we heard a different court describe that as an ambiguous situation. And they said, in that ambiguous situation, it was Wardlaw, in that ambiguous situation, the police are permitted to do a Terry stop. Now we're adding, and they're permitted to use force or threats of force to do so. Which again, to me, calls into question this idea that you are constitutionally entitled to simply go about your business and ignore the policeman. Stop and let me search you or I'll hit you with my billy club does not sound like, and you're free to go about your business. Those sound like two different statements that you would hear at two different times and two different contexts. The test of reasonableness under the Fourth Amendment is not capable of precise definition. Now, some justices, like Rehnquist and Scalia and Thomas, insist on precise formal tests. That's formalism. And we've talked about the fact that there are advantages to formalism and disadvantages, and there are advantages to a kind of fact-specific, consequence-based balancing approach. They're different. But it is interesting to see that in this context, where the police are involved, suddenly our attachment to formal tests seems to diminish considerably. Its proper application requires careful attention to facts. Okay, so, great. How do we do that? So we know we're looking for reasonableness. How do we go about it? The answer is we go about that evaluation from the perspective of the officer with specific sensitivity, as we saw last time, to the need to make split-second decisions. The reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with the 20/20 vision of hindsight. Now, I'm stopping a lot to say this is interesting, but there are a lot of things in here that are interesting, although they're interesting because of the way that they're just different. Every other time we have talked about a reasonableness standard, it has been the much ballyhooed reasonable man or reasonable person standard. This is specifically a reasonable officer standard. The reasonable officer is maybe not the same thing as a reasonable civilian. It's just yet another, right? I don't know where to go with that. I don't know what else to say about it. It's interesting. where the wrong person is arrested, where a search warrant is served on the wrong premises. None of these violate the Fourth Amendment, so long as these were innocent mistakes. Not every, and the same goes for the use of force. You can't just say you used force, that's bad. Not every push or shove, even if it later seem unnecessary in the peace of a judge's chambers, violates the Fourth Amendment. The calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments. Okay, so far pretty clear. So we're going to, best we can, we the judges, put ourselves in the mindset of a reasonable officer on that situation, on that scene, making a split-second judgment. Okay, that's how we're, but interesting, this case, Johnson versus Glick, is mentioned here. So that's the one that I mentioned a minute ago in which substantive due process was applied. And on the one hand, this case is saying, no, we're not doing that anymore. Excessive force in a Terry stop or an arrest is a Fourth Amendment question. Got it. But there's another piece. And the other piece goes like this. Because the Court of Appeals, and by the way, have a little sympathy here for the Court of Appeals. The Supreme Court says the Court of Appeals erred by relying on this earlier precedent. But of course, the Supreme Court had not yet overruled that earlier precedent. It was good law. They were required to do so. You frequently see Supreme Court opinions say, boy, that lower court really messed this up, when they were literally doing what they were required to do because the new rule hadn't been announced yet. That's not important, but so the Court of Appeals erred by applying Johnson versus Glick. Okay, fine. Didn't apply the Fourth Amendment standard. But here's what was wrong with it. The Johnson versus Glick standard said it's a violation of substantive due process if a police officer uses force maliciously or sadistically. I'm going to hurt you just because I can, is, according to that substantive due process standard, it's the equivalent of a law passed to harass or annoy a particular class. That bare animus theory that goes all the way back to Plessy. Right? Action taken for no good purpose violates our canons of fairness under substantive due process. It does not violate the Fourth Amendment. Sadism and malice do not lead to a conclusion that force has been excessive for Fourth Amendment purposes. I'm going to show you why for a second. I just want to let that sink in, though, because honestly, I like the looks on your faces. A couple. So the Court of Appeals applied this Johnson versus Glick substantive due process test. That test, which requires consideration of whether the individual officers acted in good faith or maliciously and sadistically for the purpose of causing harm, is incompatible with the Fourth Amendment. We don't ask that question when we're under the Fourth Amendment. Why not? Well, because the Fourth Amendment standard is objective reasonableness, remember? The objective police officer. But that takes the action completely away from the actual person. The actual police officer may be a sadistic thug who's hurting a suspect because he can get away with it. But if that level of force is deemed to be objectively reasonable, it doesn't matter. The Court of Appeals said that the malicious and sadistic inquiry is merely another way of describing conduct that is objectively unreasonable under the circumstances. It's a fair argument. It is never reasonable to inflict harm just for the sake of inflicting harm when you're a police officer. No. The fact remains the malicious and sadistic factor puts in issue the subjective motivations of the individual officers, which our prior cases make clear has no bearing on whether a particular seizure is unreasonable under the Fourth Amendment. So you cannot ask that cop who said, hey, he's not diabetic, he's just an asshole, right? The cop I quoted? You cannot ask, was he just looking for an excuse to go off on someone? You have to ask, and you can see how hard it is to frame this question. You have to ask, would a reasonable police officer in that situation, on a split-second basis, have conceivably used that level of force? That's it. That's the test. That's what Graham versus Connor tells us. It should be pretty obvious. That's a difficult test to fail. If that's your test, it's going to be very rare that you find that a police officer has exceeded the amount of force. Because notice, you're not asking, is it more force than was necessary? You're not asking, did the police officer know it wasn't necessary, he just did it because he liked it? Or because he was prejudiced against the suspect, or because they knew each other and were social enemies, right? You can't ask any of that. If the level of violence used, and it's a Terry stop, it's not an arrest. This is nothing more than you look suspicious to me, which can include the neighborhood you live in, looking nervous, all that stuff, running, obviously. And in that situation, so in this situation, breaking the guy's foot, cutting his wrist, giving an injury to his head, was all considered reasonable. Because a reasonable police officer confronted by that particular behavior might have done the same thing in the heat of the moment as a split-second decision. All right, Harlow versus Fitzgerald. We haven't even gotten to, well, we're about to. Yeah?
I was wondering if there's anything notable in that dissent that might be opposed.
There is, and you can guess what it is. This is awful, you're giving free rein to police to hurt people, blah, blah, blah. It's basically the dissent articulates a substantive due process kind of reasoning. This shocks the conscience, kind of a Roachin-like kind of thing. But which goes back to 1952, don't forget. That wasn't some recent invention. But the move of saying we're going to identify a specific source of the right, the Fourth Amendment, takes all, this is why I was emphasizing that, takes us out of that whole discussion. The only discussion is whatever discussion has been established in the past under the specific Fourth Amendment context, and the Fourth Amendment usually isn't about violence. As reasonable searches and seizures is not the language you usually look to say, is it okay to beat the hell out of somebody? Right? But this is violence occurring in the context of a Terry stuff. I told you, Terry does a lot of work. So now this kind of violence is away from a substantive due process, fairness, justice, procedural due process. No one may be deprived of life, liberty, etc., without due process of law. It's away from all of that. It's not the due process clause at all. It's in the Fourth Amendment. Harlow versus Fitzgerald adds the next layer, qualified immunity. So this is great. This comes out of the Watergate. Well, it comes out of Nixon anyway. Fitzgerald was an Air Force whistleblower. When testifying before Congress, he testified to cost overruns, inefficiency, and corruption in the military procurement process for these, I believe it was the C-5 cargo planes, one of the biggest planes in the world. Let us pause and express our shock and dismay that there is fraud and inefficiency in the military procurement process. I never thought I would hear that in the United States. Nonetheless, it seems to have been true in the 70s. Nixon disapproved of his testimony and by the president's own statement fired him for it. He sued, and in an initial case called Nixon versus Fitzgerald, two things were said. One, you can't sue a sitting president. So if you remember the debates when Trump was president, can he be sued? He goes back to Nixon versus Fitzgerald. This is the case that makes that rule. You cannot file a civil suit against a sitting president, period. Two, separately, presidents are absolutely immune from liability for their official actions. All right, so there's a principle of absolute immunity for presidents. So Fitzgerald turned around and sued two of Nixon's aides, Harlow and Butterfield. Butterfield's an interesting cat. Alexander Butterfield is the guy who, during the hearings in the Senate, without being asked a question about this, voluntarily brought, he said, well, if you're not sure what happened, you could check the tapes. And I think it was, I forget who it was Irvin or someone else said, excuse me? And he said, oh yeah, the tapes. The White House, the Oval Office is bugged. We have tapes of every conversation. It was just an extraordinary moment. For a long time, I had a theory that Butterfield was deep throat. It wasn't, but because of that. So Butterfield and Harlow apparently conversed with Nixon and said, you should fire this guy. And he said, yeah, I'm going to fire this guy. Okay, we'll sue them. Do they have absolute immunity? That's the question. Well, let's talk about immunity. Our cases have recognized immunity defenses of two kinds. For officials whose special functions or constitutional status requires complete protection of suit, we have recognized the defense of absolute immunity. The absolute immunity of legislators in their legislative functions and of judges in their judicial functions now is well settled. You cannot sue a member of Congress or your state legislature because they passed a law you don't like. You cannot sue a judge on the grounds that he or she ruled wrongly in a case. They're absolutely immune from civil suits. If they're taking bribes, that's a criminal case, right? But you can't just say, I'm suing you because because you ruled against me. All right. Our decisions have also extended absolute immunity to certain officials of the executive branch. Again, the executive branch is different. Why? Because the executive branch is the one who actually carries things out. It's the policeman on the street. It's the agency that comes into your factory and finds you. It's the regulatory authority that bans you from selling the thing that you want to sell. Right? The executive branch is the point where people's real life and the state hit. That's why it's so much messier and so much more difficult to make formal rules in this context, because there are the myriad possible situations that can arise. However, certain executive branch officials are entitled to absolute immunity. You already know one of them is the president. These include prosecutors. Same idea. You can't sue a prosecutor for the decision to file charges against you. Rebecca is giving me one of those looks. There is a thing called malicious prosecution. And you can, in fact, bring a claim against a prosecutor for malicious prosecution, but not in the form of a civil lawsuit for damages. These include prosecutors and similar officials, executive officers engaged in adjudicative functions, like Article 2 judges, FDA rulers, that sort of thing, and the president. Great. What about these two guys? These two aides to the president. For executive officers in general, our cases make claim that qualified immunity represents the norm. All right, so here's our new concept. It's not brand new, but so some people are just immune, you can't sue them. Some people are normal, and some people have qualified immunity. What's that? Some examples. First of all, to whom does it apply? The answer is it applies to executive branch officials who are not quite at the level of the president and are not involved in legal proceedings in the way that a prosecutor is. A governor and his aides, high federal officials of the executive branch. We explained that the recognition of a qualified immunity defense for high officials reflected an attempt to balance competing values. There we are again. So it is the essence of civil liberty, Marshall told us in Marbury versus Madison, that every citizen, every person can go to court to seek vindication where they've suffered a legal harm. Yeah, we have to balance that against not only the importance of damages remedy to protect the rights of citizens, but also the need to protect officials who are required to exercise their discretion and the related public interest in encouraging the vigorous exercise of official authority. Perfectly sensible balancing, just a little odd to hear it put that way in the context of a constitutional rights claim. So the answer is presidential aides and members of the cabinet do not have the absolute immunity of the president. They have only qualified immunity. Having decided that members of the cabinet ordinarily enjoy only qualified immunity, we conclude today it would be untenable to hold absolute immunity an incident to the office of every presidential subordinate. Okay, so we have qualified immunity. Let's figure out what that means. Well, again, qualified immunity is about balancing. A moment ago he said balancing interests. Now we're going to describe it as balancing evils, which is a nice way of putting it. The resolution of immunity questions inherently requires a balance between the evils, inevitable, and any available alternative. Right? It's going to err one way or the other. There is no perfect solution. It's a rare moment of truthfulness on that point. We're either going to have rules that are so protective of government officials that people are going to get screwed, have their rights violated, and be unable to do anything about it. Or we're going to provide people who claim their rights have been violated with a strong enough remedy that it can get in the way of the government doing its job. You may consider, for example, the, in retrospect, extraordinary claim of the U.S. Supreme Court that forcing Bill Clinton while president to sit for depositions and engage in discovery would not in any way interfere in the performance of his duties as president. Presidency scholars around the country jumped out of windows when that ruling came down. It is this recognition that required the denial of absolute immunity. At the same time, it cannot be disputed seriously that claims frequently run against the innocent. This could be used for political purposes, for example. You could have politically motivated lawsuits that could grind government to a halt. So we need to balance. The key is a good faith defense. What did we just say about the Fourth Amendment context? Good faith doesn't matter. Bad faith doesn't matter. Sadism and malice don't matter. Those are all about the subjective state of mind of the actor. In the Fourth Amendment context with the policeman, we said none of that matters. So how are these two things going to work together? The good faith has an objective and a subjective element. The objective element involves a presumptive knowledge of and respect for basic, unquestioned constitutional rights. If anybody in your position ought to know that what you're about to do violates someone's constitutional right, then the fact that you claim that you personally didn't know it isn't going to help you. So that's the objective part. The subjective part, permissible intentions. Referring to both the objective and subjective elements, we've held that qualified immunity would be defeated if an official knew or reasonably should have known that the action he took would violate the constitutional rights of the plaintiff, or if he took the action with a malicious intention to cause deprivation of rights or other injury. Well, how are we going to square that with that Fourth Amendment thing? Easy. We'll change the rule and get rid of that subjective part. We'll just dump it. We conclude today that bare allegations of malice should not suffice to subject government officials either to the cost of trial or the burdens of discovery. We hold that government officials performing discretionary functions generally are shielded from liability for civil damages if their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. So the fact that, hypothetically, although if you've ever listened to or read the transcripts of Nixon's tapes, this is not all that hypothetical. He talked this way. The fact that Nixon might have said, I want to get that son of a bitch, fire him. That'll show him. And then other people won't go around being whistleblowers and we won't have to be rah, rah, rah. Because people in his cabinet were going to prison for corruption. It was really very embarrassing. His vice president went to prison for taking bribes. That's a little rough on a president, you know? Spiro Agnew used to be a bumper sticker. Maryland has the best politicians money can buy. Spiro T. Agnew was the guy who described the press as the nattering nabobs of negativism. I miss the days when our villains could speak in poetic alliteration. Never mind our heroes, even our villains were better educated. All right. So even if you could prove, don't be thrown by the phrase bare allegation. They're taking malice out of the equation altogether. Even if you could prove that in this particular instance, this particular official was just out to hurt somebody, that's not part of the calculation here, just as it's no longer part of the calculation for a police officer using force in a Terry stop or an arrest. Got it? Furthermore, even if the right is clearly established, so any reasonable official knew or should have known, right, that you're violating a right, under special circumstances, we still might find that qualified immunity applies. If the law was clearly established, the immunity defense ordinarily should fail. Nevertheless, if the official pleading the defense claims extraordinary circumstances and can prove he neither knew nor should have known the relevant legal standard, the defense should be sustained. So it's not just that it's a clearly established legal standard, there's kind of a separate piece, and all relevant officials knew about it. This becomes a requirement of notice. Did the relevant official have notice that there exists a rule that says what they're doing is unconstitutional? Pause. The courts will not give you a remedy for the fact that the government has violated your constitutional rights in a way that harmed you unless you can prove that the official who committed the acts, that there was a clearly established rule against it, and that similarly situated officials would have known about it. The mere fact that your right to free speech was violated does not entitle you to a remedy. I used free speech. That's not how we reason in the free speech cases. We have never seen anything like this in any other context. Ashcroft versus Al-Kid. All right, one of the things that happens if you remove that subjective element, remember? And I'm repeating myself, but I want to make sure. Malice doesn't matter. Sadistic impulse doesn't matter. Personal bias doesn't matter. What about pretext? Even in rational basis scrutiny, if we find that the government actor's stated justification is a pretext, then we don't even listen to it. I mean, the stated justification, of course, I presume is legitimate. But the point of pretext cases is, no, we don't believe that you're really trying to improve public safety. We think you just don't like left-handed people, and that's why you're arresting all left-handed, or whatever it is. Right? Pretexts. We think it's a bare animus. Well, without a subjective element, without inquiring into the motives of the actor, you can't show a pretext. Ashcroft versus Al-Kid. Here's the allegation. I will naturally remain entirely neutral on the question of whether these allegations are true or not. Far be it from me to try and persuade you how you ought to see recent history in the United States. After 9/11, the Justice Department went around sweeping up people. In some cases, they swept them off the streets in the belief if they appeared suspicious. In one notable case in New York City, 3 Israeli electricians who had wire cutters and screwdrivers were held in prison for 4 weeks on the theory that they might have been involved in the... Yeah, the number of Israelis working for Al-Qaeda is really kind of limited. That's a Venn diagram. Really isn't a... Apparently, it took a month for anyone in the New York Police Department to realize that they were speaking Hebrew, not Arabic, and that their passport said Israel on it, not, Saudi Arabia. But separately, that's not what this case is about. There were some suits about that too. This case is about a DOJ thing where they went around and swept up everyone they were suspicious of, but against whom they couldn't prove anything. Now, pause for a moment. This is another one of those places where you have to step carefully or you'll trip, metaphorically speaking. We have a whole set of rules under the Fourth Amendment about what is required to take someone into custody. Probable cause. We have a different set of rules under the Fourth Amendment for what is required to do an interview and a pat-down search, Terry stops. But taking people into custody ordinarily requires probable cause, and to hold them for more than a brief period of time requires an arrest. And of course, when we did this in more detail, we could go through all the details. Exactly how long can you hold them, under what circumstances? But that's basic, right? There's a threshold you have to meet before you're allowed to take someone into custody. The DOJ did not meet that threshold. That is, they did not have information on these guys to justify an arrest. That's why I didn't arrest them. But they found a workaround. Material witness warrants. A material witness warrant allows you to take someone into custody if you can show 2 things to a judge, right? Warrants have to be approved by neutral magistrates, judges. If you can show 2 things. 1, this person's testimony is essential to a felony prosecution of some kind. And 2, if you don't take them into custody, you have reason to believe it will not be possible to secure their testimony with a subpoena. Al-Kid was arrested at the airport on his way to Saudi Arabia, so that number 2 part was pretty clearly satisfied. If we don't arrest him now, he will get away. It's the first part that's interesting. So the federal officials went to a judge, and they said, if information crucial to the prosecution of Sami Omar al-Hussein, one of the hijackers, would be lost. The judge says, oh, all right. You need that testimony. I understand that. This is an important terrorism prosecution. Here's your warrant. Go get him. Al-Kid was held in federal custody for 16 days on this basis. He was then on supervised release, make sure he couldn't run, for 14 months. He was never called as a witness. Remember, the representation of the judges, this witness's testimony is essential for an important prosecution. But he was never called as a witness. Obvious question. Was this just a pretext? They held him in a cell for more than 2 weeks, and they had, I don't know, it was an ankle monitor or something, some sort of limitation for 14 months after that, without ever having enough probable cause to arrest him in the first place. Was this material witness claim a pretext to lock this guy up? For which there may have been very, very good reason. Please do not misunderstand me. But in our system, the Fourth Amendment says there's a threshold that you have to pass before you do that. Nope. We have almost uniformly rejected invitations to probe subjective intent. Asking if it was a pretext would be asking about the subjective intention of Ashcroft and the Department of Justice. And we've already said we don't do that. Our only question is, under the circumstances, would it be objectively reasonable? Well, it's not even that, I'm sorry. This is a warrant. So our only question, was this a properly issued warrant? And in evaluating the propriety of the warrant, we can't ask, were the law enforcement authorities deliberately misrepresenting the situation? We can't ask, was it a pretext? All we can ask is, was there a showing? Did the judge sign off on it? And if there is, we're done. Now, an earlier case called Edmund opened an interesting question. Edmund involved a checkpoint where the police stopped every car and searched it for drugs. That was ruled unconstitutional. That was a warrantless search that was not constitutional. But interestingly, in that case, and citing earlier cases, it's perfectly okay to stop every car and see if there's drunk driving. or to stop every car and see if people are driving on an expired license, or to stop every car and see if there are any illegal immigrants in the vehicle. The explanation is that each of those three things is specifically tied to the operation of the vehicle. Illegal immigrants are trying to get away to avoid capture. Whereas merely stopping every car and seeing if there are drugs in it is just kind of generalizable law enforcement. So there's, as always, we look to a precedent, we ask is there an analogy, but here the analogy doesn't really matter because this case involved a particularized suspicion. The DOJ didn't set up a checkpoint and stop everyone going through fits some particular description. They wanted this guy. They had his name, and they went to a judge. The existence of a judicial warrant based on individualized suspicion takes this case outside the domain of not only our special needs and administrative search cases, but of admin as well. This is not like a checkpoint searching cars. This is a warrant for a particular person, an individualized suspicion. Yeah. But we've gone from probable cause to reasonable suspicion to any individualized suspicion. And we've done it in the context of a warrant that allows you to lock someone in jail for a period of weeks without ever charging them with a crime. And we will not ask if your articulation of your suspicion was pretextual. Imagine what it would take to fail this test. Oh no, I'm glad you asked. Very next thing. After all, we allow warrantless searches on this basis quite frequently. In Wren versus United States, we declined to probe the motives behind seizures supported by probable cause but lacking a warrant. So if you have probable cause, you can, if you stop a car and you see, and you have probable cause to think because of something you see or for some reason that there are guns or drugs or something in the car, you can seize them without a warrant. What's the authority? Come on, you can guess. Terry versus Ohio. Once you make the Terry stop, anything that develops afterwards is fair game. If you pat down someone in a Terry stop, and you feel a sort of bulge in their pocket, that's enough to make them take out what's in their pockets and see if it's drugs. Well, we review even suspicionless searches for objective reasonableness. Sometimes we allow the police to search when there's no suspicion, like those checkpoints we just talked about for drunk drivers or for illegal immigrants. If concerns about improper motive and pretext do not justify subjective inquiries into those less protective contexts, we see no reason to adopt that inquiry here. Wren versus the United States is an interesting example. It involved racial profiling. You all know the phrase driving while black? So the claim was made that the police were stopping black motorists. The claim failed not because it wasn't true or couldn't be proven, but because racial profiling was irrelevant to determine whether there was any constitutional violation. There could only be a constitutional violation if the individual stop that occurred lacked an objective basis. These are what are called pretextual traffic stops. They lead to more shootings and killings and woundings of both police officers and subjects of investigation than any other interaction between the police and drivers. A policeman approaching a car where you cannot see your hands is in a fraught position. And you've heard many stories the last few years that someone reaches for their seatbelt or their license and the cop shoots them thinking they're reaching for a gun. And in every case, the courts have always found, well, he could have been reaching for a gun, so it's reasonable. So traffic stops are an absolutely classic example, right? A Terry stop can escalate into a seizure and an arrest. A traffic stop can escalate into an arrest, a seizure of the vehicle, and an impounding of whatever's inside it. Because once you're in a place once the police officer's in a place they're entitled to be, whatever comes out of that is fair game. So in Wren, the claim was, you're not really trying to enforce traffic laws. You're just stopping black people. And it's not that they couldn't prove that, it didn't matter. In Wren, our unanimous opinion held we would not look behind an objectively reasonable traffic stop to determine whether racial profiling or a desire to investigate other potential crimes was the real motive. Right? Pretextual traffic stops happen sometimes because the cops want to talk to that guy because they think he's involved in a crime, but they have no evidence. But once you can stop him for driving over the yellow line or having a busted taillight, or it's almost impossible not to violate some law when you're driving. Once you have them stopped and are speaking with them, now you can go and ask about other things. Are they entitled to go on about their way? No, because you've stopped them for a crime or an infraction. This is no longer a Terry stop. This is a traffic stop, a pretextual traffic stop. Yes, sir? No. Legislators have complete immunity.
Right.
And for legislators, motive matters. A law that is passed with the motive of suppressing religion, or the motive of harming an unpopular group, or the motive of infringing on free speech rights, those motives make those laws unconstitutional. It's only here. This is the only place we say, we don't care if you are racially profiling, unless you can show that the particular stop that the particular person is suing about was unreasonable. The fact that it was motivated by racial animus, or motivated by a desire to get at a suspect whom you couldn't get to otherwise, so you didn't have sufficient evidence, is irrelevant. So, let us apply the test here. You remember, of course, how often we've talked about the specificity with which rights are described. Al-Qaeda is going to lose because there's no right under the Fourth Amendment not to be the subject of a pretextual material witness warrant. We've never said in earlier cases that it violates your constitutional rights if you are arrested under a material witness warrant that is actually a pretext. Therefore, it's not an established right. Therefore, there's no notice. Therefore, qualified immunity. That's how this works. At the time of Al-Qaeda's arrest, not a single judicial opinion had held that a pretext could render an objectively reasonable arrest pursuant to a material witness warrant unconstitutional. Notice how that's phrased. Pretextual arrests have been ruled unconstitutional. But there's no case that said a pretextual warrant that's issued on a material witness basis is unconstitutional. The Court of Appeals cited cases, but the cases that they cited are the ones that the majority has rejected. The Ninth Circuit found clearly established law lurking in the broad history and purposes of the Fourth Amendment. Bad Ninth Circuit. Shame on you. That's not how we do this. You need a specific right to be free from pretextual material witness warrants, not some general principle of unreasonable searches and seizures. Where do you even get language like that? We have repeatedly told courts, in the Ninth Circuit in particular, right, let's scolding them, not to define clearly established law at a high level of generality. The general proposition that an unreasonable search or seizure violates the Fourth Amendment is of little help in determining whether the violative nature of particular conduct is or is not clearly established. Right? You can say this violates the Fourth Amendment, and we can debate it and have a discussion. You can reach a conclusion. You might conclude, yes, this violates the Fourth Amendment, but that's not the question. We're no longer talking about the right. We're talking about the immunity of the actor when they violated that right. And the question for the immunity of the actor is about this clearly established fair notice thing, which doesn't have anything to do with how much your rights are violated or not. Qualified immunity gives government officials breathing room to make reasonable but mistaken judgments about open legal questions. When properly applied, it protects all but the plainly incompetent or those who knowingly violate the law. Ashcroft deserves neither label. So yeah, maybe Ashcroft violated this guy's Fourth Amendment rights, but we had never specifically said so. Therefore, Ashcroft, the Attorney General of the United States, could not be expected to know that this action violated the Fourth Amendment. Therefore, he's entitled to qualified immunity. Rivas Villegas versus Cortes Luna. Okay, these doctrines have unsurprisingly inspired a lot of criticism. Interestingly, on the court, the two justices who are most critical of qualified immunity, but keep in mind, this is completely a judicial invention. Qualified immunity didn't exist before 1982. You have these really interesting arguments going around now where people say if you get rid of qualified immunity, the police won't do their jobs and will be awash in crime. Well, then how come before 1982 we weren't awash in crime? Behavioral economics strikes again. There are many stupid people in the world, but stupid economists are just a very special breed. It's the end of the semester. I'm slipping a little. My veil of neutrality. See, These, interestingly, on the court, the two justices who are most critical of these doctrines are Sotomayor and Thomas, which is not a lineup you see every day. So this isn't even about our standard judicial liberal, judicial conservative thing. Something fairly deep is going on here. The other area where you'll see that same kind of concern is with civil forfeitures. The police can take your property and never give it back, even if you didn't commit a crime. It's a whole different story. Well, we don't have time. So in 2021, there were two cases that came up to the court, and a lot of observers thought, aha, maybe they're going to revisit this issue. Maybe they're going to revisit qualified immunity and make some new standards or clarify some questions at least. They did not. They declined to, they upheld the lower court's finding of qualified immunity in both of them. We're going to look at one of them, Rivas Villegas versus Cortes Luna. Mostly because that's just such a beautiful, Rivas Villegas versus Cortes Luna is a beautiful name. So here's the deal. There was an earlier case called Lalonde in which the police were found to have acted so egregiously that they were not entitled to qualified immunity. Rivas Villegas claimed that the police in his case similarly should not be entitled to qualified immunity. The reason for looking at this case is twofold. One, to illustrate that in 2021, which is now, the Supreme Court had a chance, if they wanted to revisit this question and clarify it somewhat or alter the rules or, what the court does. And they didn't. And two, to emphasize how, as a result, everything is incredibly fact-specific and dependent to an extraordinary degree on that fair notice provided by an earlier case that's sufficiently identical. And of course, the question is, what is sufficiently identical? So I think, by the way, you'll agree that in this case, the police acted perfectly reasonably, but it's the reasoning of the court that I'm much more interested in. So there was a domestic disturbance call. The police showed up. If you read the case, the excerpt, you'll see the details. Rivas Villegas came in the door. He was ornery. At a certain point, the police realized he had a knife in his pocket. They shot him with a couple of beanbags, non-lethal beanbags, once in the stomach, once in the hip, got him down on the ground. The police officer kneeled on his back for a period of about 8 seconds while they removed the knife from his pocket, then hauled him up and put him in handcuffs. All right. Now, Lalonde, according to the Court of Appeals that ruled against the police officer, was similar. Both Lalonde and this case involved suspects who were lying face down on the ground, who were not resisting either physically or verbally, and on whose back the defendant officer leaned with a knee, causing alleged significant injury. That's the claim. Well, says the court, and you got to read this carefully, even if it were clearly established as a matter of law, federal law in this circuit, that under Section 1983, the policeman's actions in kneeling on this guy's back was a violation of his rights for which he's entitled to sue for damages, even if we assume that that's true, it doesn't matter. Why doesn't it matter? Because the precedent of Lalonde is not sufficiently like this case to give the policeman fair and adequate notice that there exists this clearly established law. We're breaking this into two different questions. Is this a clearly established right? And has the policeman been given notice that this is a clearly established right? Even if there's or phrase it slightly differently, even if there's a clearly established violation of rights, unless our earlier opinions in cases have been sufficiently like this one that the police officer should know that there's a clearly established right, qualified immunity protects them. Yes, sir? Yep. The right is clearly established. So remember, two different parts of this. Clearly established and notice. When it is sufficiently clear that every reasonable official would have understood what he is doing violates that right. Although this court's case law does not require a case directly on point, existing precedent must have placed the statutory or constitutional question beyond debate. This inquiry must be undertaken in light of the specific context of the case. So it has to be beyond debate, and it has to be specific. So it can't be, for example, is it ever the case that kneeling on a suspect's back violates their constitutional rights? It can't be, is it ever the case that kneeling on a suspect's back when they're face down on the ground and not resisting violates their constitutional rights? It has to be, was a specific conduct in this case violative of a clearly established right, and was there notice of that fact? Whether an officer has used excessive force depends on the facts and circumstances of each particular case, including the severity of the crime at issue, whether the suspect poses an immediate threat, whether he's actively resisting arrest or attempting to evade arrest, and that's Graham versus Connor, in Tennessee versus Garner. Remember what Tennessee versus Garner was about? An unarmed suspect running away was shot in the back and killed. Yeah, but he's running away. In an obvious case, these standards can clearly establish the answer even without a body of relevant case law. So there's the answer to your question. But this is not an obvious case. Thus, to show a violation of clearly established law, see these two questions, I'm suggesting they're separate questions. I'm going to treat them as one question. In order to show a violation of clearly established law, Cortes Luna must identify a case that put Rivas Villegas, I had them backwards, Rivas is the cop, on notice that his specific conduct was unlawful. So not is it unlawful to kneel on the back of a suspect who is not resisting, but is it unlawful to kneel on the back of a suspect who is not resisting for 8 seconds for the purpose of removing a knife from his pocket before you pull him up and put handcuffs on him. You get a case that says that. The answer is no. Lalonde is different. In Lalonde, officers were responding to a neighbor's complaint that Lalonde was making too much noise. When they knocked on the door, he appeared in underwear and t-shirt, and holding a sandwich. They knocked the sandwich out of his hand. They stormed into his home without a warrant. One officer grabbed him by his ponytail. He was a hippie. Saw that coming. Threw him to the ground, sprayed his face with pepper spray, deliberately dug his knee into his back with a force that caused him long-term, if not permanent, back injury. In Lalonde, officers were responding to a mere noise complaint. Here, they were responding to a serious allegation, a serious alleged incident of domestic violence. Lalonde was unarmed. Cortes Luna had a knife. Rivas Villegas placed his knee on Cortes Luna for no more than 8 seconds and only on the side of his back near the knife. Lalonde, in contrast, testified that the officer deliberately dug his knee into his back when he had no weapon and made no threat. What do we get from all this? Maybe what the cop did here was a violation of Fourth Amendment rights. And maybe it would be treated in a proper case as following from Lalonde, it was a consistent rule. But it wasn't, but Lalonde is not specific enough to have given the officer fair notice that kneeling on people's backs is no longer a good idea for Fourth Amendment purposes. On the facts of this case, neither Lalonde nor any decision is sufficiently similar. For that reason, we grant Rivas Villegas' petition for cert and reverse the Ninth Circuit's determination and give him back his qualified immunity. All right, a few other examples. Police in a high-speed chase forced a car into a ditch, rendering both the driver and passenger crippled. Qualified immunity applied because a previous case involved the police running a car into a tree. There was not a previous case involving running a car into a ditch as opposed to a fixed obstacle. Jessup versus Fresno. This is my favorite. While serving a search warrant, police officers stole $225,000 from the house in cash and jewelry. The homeowners sued them for stealing her belongings. They were protected by qualified immunity. There had never been a case that said when you're serving a warrant, you can't steal people's property. And so the police officers, according to the Ninth Circuit, were not given fair notice that stealing $225,000 worth of property from a house which you're searching under the authority of a warrant could be violative of somebody's constitutional rights. Kelsey versus Ernst, 2019. These are all 2019. Well, these three are. Woman called the police because she claimed she was being, was at a pool, public pool. She claimed she was being assaulted. A guy was groping her and harassing her. The police showed up. At one point, she walked away from the cop. He said, "Get back here." When she didn't, he grabbed her and body slammed her on the concrete, causing her significant injury. Protected by qualified immunity. There was no case that specifically said that when you're dealing with someone who is a complainant rather than a suspect, it violates our constitutional right to body slam them on the ground. Corbett versus Vickers. A sheriff's deputy was chasing a guy and came across a kid and his dog. The dog was noisy. The dog was not attacking the police officer, but he was noisy. And the cop said, "Make your damn dog stop barking." And the kid wouldn't, so the cop shot the dog. But he missed and killed the 10-year-old boy. Protected by qualified immunity. There was no particular case that said shooting at a non-hostile dog, missing and killing a 10-year-old boy violates the constitutional rights of that boy when it's by a policeman. Multiple cases. Precision immobilization. PIT, precision immobilization technique. You've probably seen this on television. If there's a high-speed chase going on, I love the name precision. This is about as precise as, well, anyway. That's a spray gun. The idea is that the police car will pull up parallel to and just behind the fleeing car and deliberately ram it on one side of the rear fender, causing it to spin. That will cause the car to stop and you'll be able to apprehend the driver. Guess what often happens? Remember, these are high-speed chases. So if you're going 80 or 90 miles an hour, guess what happens a lot? Yeah, the cars go flying. At least 30 people have died, been killed, and hundreds have been injured by the use of PIT technique in the last 5 years, according to a study by the Washington Post. But because it has never been ruled that that technique is unlawful, in every single case, qualified immunity applies. Is there any limit to this? Martinsburg versus West Virginia. Fourth Circuit case from 2020. This came out in March of 2020 when COVID was hitting. Maybe that's why I didn't get more attention. I confess, I didn't notice this when it was a Fourth Circuit case, not a Supreme Court case. And there was a lot going on in March of 2020. A guy named Wayne Jones, a black man who was homeless and appears to have had at least some psychological issues, which is very often the case with homeless people. You know about the mainstreaming of mental patients onto the streets that helped create some of these situations. Was stopped by law enforcement. The reason for stopping him, he was walking in the street, not on the sidewalk. In what followed, he was tased 4 times, hit in the brachial plexus, kicked, placed in a chokehold. Ultimately, he was in the situation of lying motionless on the ground in front of a stone wall. But one of the officers says he has a knife. He had a short, according to the opinion, a small fixed blade knife in his sleeve. 5 policemen shot him 22 times. They said, give up the knife, and he didn't move or answer. He'd already been tased 4 times. Have you ever been tased? Yeah, very few of us could do anything after being tased 4 times. They said, give up the knife, and he didn't. He just lay still because he was out. So they shot him 22 times. The lower court found qualified immunity. There is no case on record that said just because someone is lying and unresponsive doesn't means you can't shoot them. If it's possible, there might be a weapon somewhere in the area. The Fourth Circuit, which is usually a very conservative and extraordinarily pro-police circuit, a conservative generally, but they're finally may have had enough. We are asked to decide whether it was clearly established that the 5 officers could not shoot a man 22 times as he lay motionless on the ground. Although we recognize that our police officers are often asked to make split-second decisions, we expect them to do so with respect for the dignity and worth of black lives. Before the ink dried on this opinion, the FBI opened an investigation to yet another death of a black man in the hands of police, this time George Floyd in Minneapolis. This has to stop. That was in 2020. Fourth Circuit sent the case back to trial court and it's proceeding. It may yet reach the Supreme Court. Maybe that one will be one that gets their attention and causes them to reconsider qualified immunity. At the moment, those are the rules. Unless you can show a precedent, unless you can show a precedent that with specificity, in all the same ways we talked about specific powers and specific rights, puts the police on notice that doing X would be a violation of constitutional rights, and the mere fact that they have violated someone's constitutional right, that they may have done so maliciously or sadistically or on a pretext, is all irrelevant because they are protected by qualified immunity. That's it. Next week we'll talk about democracy.